Let's get started, and it's my absolute pleasure to hand over to Dave Parsons from DHCW. Dave, it's over to you.
I say good morning, but it's afternoon. No, afternoon, everybody. Thank you very much, Suzanne, and it's great to be here. And thank you very much for inviting us along for the opportunity to talk around the world of data protection in particular. Perhaps hopefully by the end of today's session, killing off some of the myths that we know still exist around data sharing activities. Just going to share my slides. Fingers crossed technology works for me. This is where things usually go wrong, so perhaps today will be a good day. So my name's Dave Parsons. I'm the Wales Accord on the Sharing of Personal Information Manager within Digital Health and Care Wales. A number of colleagues might know me from past experiences working within Cardiff Council in particular. But I currently now lead the WASPI team. That's the national lead in terms of information sharing activity and the Wales Accord for Wales. I've got two of my colleagues here today, Marcus Sandberg and Ben Tuckett. Ben and Marcus are absolutely pivotal in the world of WASPI, and they will be participating as we go along this morning. And in terms of their roles also include supporting information governance practices across Digital Health and Care Wales as well. So supporting all of our health boards and trusts, which is by no means a simple task. But in terms of from a WASPI perspective, they cover off all of the assurance work that comes in. So when we create ISPs, looking at the initial quality assurance of something that's provided by a partner, all the way through then to supporting organisations with getting that signed off and then published on our national website. So I guess as Suzanne has put it, and as the advert has gone for today's webinar, we are talking about data protection and in terms of it being an enabler, and it's something that's very, very close to my heart and close to a lot of the things that we do and we lead with in Wales. In terms of data sharing, there are no special rules, right? There are no special rules that organisations can apply. Data sharing is, in theory, just another form of processing when it comes to the data protection principles. But what I always say is, I guess, look at your basic things to start with. You're always going to have to obviously clearly consider your data protection principles when it comes to sharing of information between partners, agencies and third parties. But the key thing is identifying a clear lawful basis. And one of the clearest ways of being able to achieve that really is understanding and knowing what your actual purpose is right from the offset. If you know what it is you're looking to do and you understand what the benefits are that you're looking to achieve, then you're very likely to understand what partners you want to actually share information with. But also you're going to be able to assess any risks that might be posed by that information sharing activity as well, which will feed out of it then your clear lawful basis of what you should be doing. I've not got it on the slide here, but there's actually some really good guidance from the National Archives, and they class it as 7 golden rules, and I think these are really good golden rules actually, and that's when it comes to data sharing, always look at what's necessary, what's proportionate. Just because we can do something doesn't mean you've got to give absolutely everything. And that's where it comes into looking at what that purpose is around data sharing. What's relevant to share with an agency, with a third party, making sure it's adequate, it's accurate, and timely. So there's no point in sharing information that potentially is live information, which will constantly change and evolve for the purpose of what you might be looking to achieve. So you've got to consider these things. And obviously, most importantly, ensuring that whatever you do it in a secure manner. In Wales, we're very fortunate, so a lot of what I'm going to talk about for the next 5 minutes is going to be based on the Wales Accord on the sharing personal information, which some of you may or may not already be familiar with. For those of you that are, apologies. For those of you that aren't, here's an opportunity to learn a little bit more around what WASPI is. We are fast approaching, in terms of WASPI, almost 20 years of the existence of the Wales Accord. Which is remarkable, and even more remarkable that I can remember when this was first created, and I've been working with it pretty much since it started. and I'm still only 21. So the Accord is based on it's a framework. It's a set of principles and standards that help organisations confidently, consistently set out how they're sharing information with third parties. And the key word in there is consistent. What we had back 20 years ago were organisations trying to pull together agreements that were setting out how information sharing practices were taking place, because information sharing has always happened. It's happened before GDPR, it happened before the 1998 Data Protection Act, it happened before the Act before that. Information sharing has always been there, but the challenge has always been for organisations around how they document and do it in a consistent manner. And that's where WASPI was born. It was born from a number of public sector bodies coming together and going, well, how do we try and alleviate these concerns and issues that we've got with lack of consistency? And that's led us to, develop over the time a number of standards and templates that organisations now use. And I think it's definitely fair to say that it's become really well embedded in the culture of what we do in Wales. Whenever organisations tend to talk around data sharing activities, the first thing they think of is WASPI, and I'm not talking about the women's against state equality inequalities. So just to get that one out there as well. WASPI does have a couple of abbreviations, but we're definitely talking around data sharing practices. But the templates are there to help organisations, and they help gain, gather that consistency and ultimately provide that confidence for organisations around what we're doing. We have information sharing protocol templates. We also have data disclosure templates, where perhaps you've got one-off or ad hoc data sharing activities, between one or two organisations. And we are looking to expand that further. So look out over the coming months for further information from us around looking at more template standards that hopefully can help organisations, again, in a consistent manner with documenting, data sharing practices. WASPI came into its own during the pandemic. It provided organisations with a huge ability and comfort to be able to set out data sharing activities in a very quick and efficient way. And it's been really pleasing to see that the Institute of Government, so there's been a long piece of work that's been conducted looking at how information sharing practices were occurring during the pandemic, what the challenges were in some nations and some regions. But the one thing that's been absolutely pivotal in the report that was published earlier this year is the fact that WASPI is recognised as being absolute best practice, and that Wales were put in a great position to be able to set out their information sharing practices, not just in relation to things such as track, trace, and protect, which was a massive challenge for organisations. When you've got 8 or 9 health boards, trusts, 22 local authorities, other public sectors trying to come together and work together, that can be a challenge. But WASPI proved to be the enabler for us, and I'm sure that's something that would be echoed by both Anna and David as we go along this morning. But like I say, it's been recognised, and it's really important that we sing from the rooftops, and we should be actually proud that we have this in Wales. I know that there are a number of organisations across the other UK nations that are very envious of what we've got. In terms of where we are with the Wales Accord, as I mentioned, we've got a huge number of partners. Ben will allude to them in a second. These are just some of our main public sector partners that are signed up and committed to the Accord. But as I say, Ben will give some further information around what that currently looks like on the present day.
Thank you, Dave. So as you can see, we have quite a fair few partners. We are currently sitting at approximately 780 organisations that are signed up to the current framework. We've had a big insurge of GPs and education providers over the past few months signing up, which is a good thing as we're trying to get as many as we can. We've also had quite possibly one of the biggest ones in recent months being Care Inspectorate of Wales, and we're currently in the process of onboarding them getting them up to speed with how they use the WASPI templates to provide their information sharing. And we're also constantly growing. We've had more and more interest in WASPI from every aspect of, services to people, local authorities, housing organisations and voluntary sectors as well. So the aim is we do work with all these organisations, and we have over 250 approved ISPs or information sharing protocols, which are available on the WASPI website. And how we provide these templates, and also we provide a method of assurance, is through our 5 regional groups, which are all supported by us, the central WASPI team, but also have a chair that is local to that group from the police force, for example, of that area. And they also partake in a WASPI management board where we share updates and we share sort of key information prior to our future plans for WASPI. And obviously WASPI is registered and recognised by Welsh Government. And we have supported schemes that they've done, most recently including the Ukrainian resettlement programme, but also stuff that comes in all sorts of aspects, sort of Flying Start schemes, MARACs and preventions of crime across all of Wales. And as Dave likes to brag, we do have no equivalent framework in anywhere else in the UK.
Thanks, Ben. And I might touch on something that David Teague might pick up a little bit later, but I think that it's fair to say that, in terms of data sharing and, really trying to set the scene around some of the myths that we've got, I think as organisations, we all come across individuals that say we can't do something because GDPR prevents us from doing it. It's been a common theme for the past 20 plus years that I'm aware of. It does happen. And what we have to remember is that the law is there to actually enable us to do things. And I think it is, it would be fair to say that from an ICO perspective, and again, I don't want to cover too much that David might cover, but I don't believe the ICO have ever fined an organisation or taken huge enforcement action against an organisation for data sharing activities. And it's not to say that they won't, but I think the key thing is if you've got a rationale for doing something and it's proportionate in the circumstances, then that is always going to be your key. There are significant areas where data sharing needs to be improved, and nothing hits that more recently. We've had multiple child practice reviews, for example, over recent months, recent years. The case involving the young boy from Bridgend, Logan Mwangi, was again another really bad example and a bad case. It had don't get me wrong, it had multiple issues around this and multiple failures, but it's fair to say that one of the things that was recognised from that case was the fact that information sharing is absolutely crucial to the work that we do. From a child protection perspective, from a safeguarding perspective, there are so many agencies involved in work support to children and vulnerable people that it really is crucial that we're sharing the right information at the right time, at the right speed, to ensure that the best services are being provided to individuals. So it's just really ramped up the importance. And this is one of the things that WASPI is great for. We can help organisations document the data sharing activities, but actually sometimes more importantly is getting organisations to review what they've got, because it's all well and good to create something and say this is what you're doing, but if you don't regularly review the agencies and partners that you're sending with, that can actually create a much bigger problem for organisations. So that's what WASPI is designed for. The templates are there for that reason. The due diligence in the background is there to be able to chase organisations to review these things regularly as well.
Thanks, Dave. And as you've explained with your child practice example on the previous slide, there's still steps to go in terms of improving information sharing in Wales, and therefore that shows the importance of needing to promote information sharing and improve the current WASPI framework. And over the next slide after this, we'll touch upon one of the ways in which we look to do that going forward with WASPI. But before we look to the future, I think it's also important to take a step back and realise how far WASPI's come. As Dave explained, WASPI came from a group of public sector organisations coming together who identified the need to share personal information across organisations. And from some of the things which were mentioned through Dave and Ben earlier, the successes of the frameworks today, and the initiatives and the programmes that it sets out to support, some of which are on the slide again here. Some of the ones on the top left where we're talking about the things that Ben spoke about, the initiatives which WASPI has supported through development of information sharing agreements through the likes of Team Around the Family, Families First, MASH and MARAC, the kind of multi-agency meetings and a whole range of different sectors, all of which, as Ben said, you can find on our website as published examples of good practice. But then jumping over to the top right then, it's also about large national, some of the things which we also support are large national initiatives within health, two of which are on the screen there. We've got the National Data Resource and the Data Promise, two large pieces of work which are no doubt going to revolutionise the way in which we use and hold health and social care data within Wales. And so we're very happy to say that the principles of WASPI are very much aligned within those projects. Very similarly then, bottom left, as Dave explained, we, in terms of the WASPI team, Ben, Dave and myself, work within Digital Health and Care Wales, an organisation which provides systems and services to organisations, NHS Wales organisations. And of course, all the things that we do within Digital Health and Care Wales are aligned to WASPI, and Digital Health and Care Wales are passionate about making sure that WASPI is as good as it can be. And the last thing on the slide is right in the middle on the bottom is around legislation. Of course, WASPI needs to be reactive to whatever changes the legislation happens. We did a major review of the framework in 2018 to reflect the changes in data protection legislation, and subsequently did another review when the Information Commissioner's Office Data Sharing Code of Practice came out to make sure that WASPI and its principles align with that. And of course, we've got to look forward to whatever changes to legislation and guidance happen in the future to make sure WASPI align to that. And to finish off our part of the presentation, I just want to talk about the next steps, the future of WASPI. And for a number of years, WASPI has been working on creating a code of conduct specific to the WASPI framework. Now, a code of conduct, for those unaware, is set out in UK GDPR under Article 40. It's more than just guidance and best practice documentation. It's about materials specifically designed to enhance the application of data protection law to a specific sector. And therefore, as you can imagine, the WASPI Code of Conduct which we're developing will be focused around information sharing, specifically the Information Sharing Protocol, a template which we host on our website. And what the Code of Conduct will allow organisations to do is to apply for this level of membership where they're looking for that additional level of assurance. And I'm keen to stress, as detailed on the slide we've got here, that this builds upon the existing framework. It doesn't replace what we've already got in place. Therefore, going forward, WASPI will have a two-tier membership going forward. We'll have the WASPI Accord membership for those wanting to follow good practice and using our templates and guidance material, as is now. And then for those organisations, as I mentioned, looking for that additional level of assurance, they can apply for this code membership. And I won't go into the ins and outs of the Code of Conduct because we recently held a consultation on the proposed code, which we've got, the documentation is on our website. If you want to find out more about that, please check out our website. And this consultation we held earlier this year asked for feedback on the proposed code. And thanks to everyone who provided feedback to that. It was very useful looking to see how we move things forward. The next step for us now is to pull together a summary report of that feedback and address some of the themes which come out of it. And we'll be looking to publish that within the coming months. Following publication of that summary document, we are intending then to progress and submit the code to the Information Commissioner for approval. We know it's going to be a bit of a long process. We know there's going to be potential changes to the code, which we've already published as a draft on our website, but we're very much looking forward to that opportunity. No other codes exist at present, and therefore we're at the very front of this and one of those organisations leading the way on codes of conduct. It's an exciting time for WASPI, and we'll continue to keep you involved through the website and through the newsletters which we send out, which are also available on the website. If you want to find out more about WASPI, then you can go to our website, which is waspi.gov.wales. That's waspi.gov.wales. And if you've got any queries or issues or questions about WASPI whatsoever, then Dave, Ben, and myself are here to be able to provide as best advice as we can do. Our contact details are on that website, but also if you want to get in touch with us, then the best way to do so is via our email address, which is waspiservice@wales.nhs.uk. That's waspiservice@wales.nhs.uk.
Thanks very much, Marcus. And yeah, as Marcus has alluded to, if anyone's got any questions at all, please feel free to reach out to us. I know there might be some time for questions and answers later in the webinar today as well. And with that, I'm going to pass over to Anna. Anna, I'll allow you to introduce yourself and I'll stop sharing my screen.
Thanks, Dave, and thanks to Marcus and Ben for your sections as well. I think just it's safe to say WASPI's been an integral part of what Welsh Government have done over the last few years in response to the pandemic and also to the war in Ukraine. WASPI's been a key part of our data sharing arrangements. I'm going to hope that my system works and shows you some slides. I'm going to talk about something slightly different. I'm going to talk about the data sharing powers in Part 5 of the Digital Economy Act. I think having looked at the attendance list, I recognise a lot of the names, but for those who don't know me, I'm Anna Bartlett-Avery. I'm Head of Data Sharing and Data Ethics within Welsh Government. I lead on our deployment of the use of the Digital Economy Act data sharing powers, but also a range of other things involving data sharing, including the pandemic, data shares, and also COVID. So the Digital Economy Act was introduced in 2017, and Part 5 specifically covers data sharing. And it was in they started with a problem. So it's a piece of UK government legislation. We all know that data is critical for the delivery of public services, and that doing public service delivery efficiently requires joining together data from multiple public sector bodies. But the legislative framework that enabled public authorities to do that was really complex and had grown piecemeal over time, which meant that public authorities really found it quite difficult to understand what data they could share, with whom, how they could do it, the best way to go about it, the consequences of getting it wrong, and a whole host of other things. But that often meant that data simply wasn't shared, or when data was shared, it was only done once a primary legislative gateway was put in place. And those are still available and they can still be done, but they can take years to put in place. So the Department for Digital Media and Sport undertook a long policy making process with public sector, civil society, and a bunch of stakeholders to develop proposals for new legislation. And the outcome was Part 5 of the Digital Economy Act, which provides a series of legal gateways that enable data to be shared much more easily between public authorities, in most cases without the need for additional legislation to enable that. So they introduced a brand new set of powers, as I've mentioned, product of collaboration between a range of stakeholders, not just public authorities, but also the private sector, civil sector, and academia. And they are the most extensive new package specifically around data sharing for a very long time. It introduced 7 powers. I'm only going to talk about 3 here because there's only 3 really that cover the disclosure of personal identifiable information. The rest are more around aggregate data or statistics or anonymized data. So I'm going to focus on numbers 1 there, so improving public service delivery, and then 3 and 4, recovering debts owed to the public sector and combating fraud against the public sector. The first of these I'm going to look at is the public service delivery powers, and 2 conditions must be met for a public authority to use these. The first is that the public authority must be a specified person And what that means is that the public authority is named in a schedule to the Act itself. There are a number of schedules, and they name public authorities for different reasons, but a public authority must be named there. And secondly, that authority must also be specified against an objective that's set out separately, and those are set out separately in regulations. There are 4 existing objectives set out in a piece of legislation called the Digital Government Disclosure of Information Regulations 2018. Multiple disadvantages, which is to help public authorities identify and support individuals and households who are subject to more than one of a defined list of disadvantages. Those things being they are disabled, they're unemployed, they're young people not in education or training, they're care leavers, they are perhaps the victim or have perpetrated some form of domestic violence. They could be subject to antisocial behaviour. For anybody that was familiar with the DWP's Troubled Families programme, that set of disadvantages would probably be quite familiar to you. And the purpose of this objective was to allow public authorities to share data in order to target or improve the delivery of services to people who are subject to more than one disadvantage. And that could mean improving their physical, mental, emotional, social, or economic well-being. The second was an incredibly important thing at the time when they were doing these regulations, and it has never been used. It was intended to allow public authorities to share data about people who might need assistance if they moved the bandwidth of terrestrial television. It's never happened, but it was incredibly important at the time. And then the third and the fourth are very similar to each other. They allow public authorities to share data about people who are living in or potentially at risk of fuel or water poverty. Obviously, that's quite a topical thing at the moment, obviously, with the cost of living rises. These 2 powers are by far and away the most used, particularly the fuel poverty objective, which allows public authorities to share data with and from utility companies as well. So it's often been used to verify that someone's in receipt of a qualifying benefit for a welfare scheme. There is one other objective that is solely available in Scotland around their childcare offer. So new objectives do come on board periodically, and UK government are currently considering another set of objectives, one around what we're describing as early help, which is getting at people before they're multiply disadvantaged. So the multiple disadvantages, you need to have 2 in the list, but if you've only got one and are at risk of another, data can't be shared about you. But an early help one might allow public authorities to get in a little bit earlier. And also important to note that they're also considering, as part of the Data Protection and Digital Information Bill, I think that's what it's called, David will correct me if I've got that wrong, extending these powers to allow public authorities to share data with the purpose of improving the delivery of services to businesses. That's not come online yet, where that's dependent on that act coming through, but they'll also be considering an objective around supporting businesses that might come online in the future. So which public authorities can use the powers? This is a list of fully devolved organisations that can use it. And you'll see for the most part, every public authority that's devolved in Wales has access to most of the powers, with the exception of the NHS, which is a sticky thorn that we struggle with a bit. We were able to name them for Wales, but they're not currently named against any of the objectives, but that doesn't mean that data can't be shared. We would just need to establish a new objective that was Wales only. And I'll come on to that a little bit in a later slide. And then we have the English and UK-wide bodies. So it's the public authorities you would expect. DWP, HMRC, the local authorities in England, policing obviously not devolved in Wales, schools, land registry. So a whole bunch of public authorities can all share data for the purposes of one or more of those objectives. Establishing new objectives then is a question I often get asked. So how do we go about that, and what does that need to look like? So there are a number of conditions that must be met. The first being that they are intended to improve, target, or facilitate the delivery of public services. The second being that their intention is to improve the well-being of data subjects. So it can't be a punitive purpose. You've got to be doing it to help people. And then the third being that data can be shared using the Digital Economy Act if it supports the delivery of a specified person or public authority's statutory functions. So you can't use them to share data outside of your statutory functions, but you can use them if what you're intending or wanting to do is part of your core set of things that you do. And then there are also some general principles that need to be applied, and I kind of alluded to the first one, is that they can't be punitive. You can't establish a new objective to identify people who are fiddling the benefit system. That's not what they're for. They have to be to benefit people. They must be specific and not general. That's often not entirely clear what that means. What we describe it as, it can't be something like, let's improve the economy of Llanelli. That's too general. But they also can't be too specific either, because if it's too specific, they're not broadly usable, and it's hard to make them work. And then the third is just a general GDPR data protection principle that only the data that's relevant and what's necessary to achieve your aim can be shared. What that often looks like is, for example, a utility company approaches DWP to verify somebody is in receipt of qualifying benefits, and they'll give a name and perhaps an address and a date of birth, and the utility and DWP will simply return a met the conditions or not. They won't say how. They will just say yes, meets the set of predefined criteria, because that's all the utility company needs to know, is that they either meet it or they don't. So that's generally how they work. Setting new objectives depends, and who does it depends on where they are. So if it's devolved public authorities only, say it's Welsh local authorities, Welsh Government and Digital Health and Care Wales, that can be done in the Senedd, and that's something that Welsh Government would progress. If it includes a non-devolved or an English body, that has to be set by Parliament. So if it includes DWP or HMRC or DVLA or any of the big UK-wide data departments, it has to be done in Parliament. And Welsh Government has strong relationships with the UK Government over these. We're engaging with them regularly. So if there was something that needed to be done, we have a clear route in. So those were the public service delivery powers. I'm just going to talk briefly about the debt powers and the fraud powers. They work a little differently. Public authorities that get to use them just simply need to be named in the schedule. They don't need another piece of legislation. So if a public authority is named, they are able to share data for the purposes of identifying, tackling fraud. And that means a lot of things. So that could be, if you have something you think might indicate somebody's doing something they shouldn't be doing, you can get information from another public authority that might allow you to verify that. It also might allow you to gather data that would enable the prosecution of fraud. This is a much smaller list, as you'll see. Welsh Ministers, the Council General, local authorities and social landlords, and then third parties. So if you have an organisation that you subcontract some work to, they are also allowed to share data, assuming all the other conditions are met. And then the fraud powers, much more extensive list, but they work very similarly. If you're this was designed to mirror the set of organisations in England that were named against these powers. We can add additional bodies to this if needed. So one of the things we have been thinking about over a period of time is whether we should add part of the NHS into the fraud powers. Difficult one, that, given the nature of the data you hold, but that's something that we've been considering. How you use them, I won't go into a huge amount of detail because I could spend sort of an hour talking about how you go about using the powers, but there are there's a code of practice that needs to be followed, and that sets out both how you establish new objectives and also how you go about using the powers. So it requires things like you undertake a data protection impact assessment, you identify what data you absolutely need, that these processes and that they are regularly reviewed, and that if they're not working, they stop. The data sharing agreements, certainly at least the broad scope of what they do, that they're published. So we're doing this in the open and it's transparent. And at the moment, there are 2 review boards at a UK level. One considers just simply new objectives under the public service delivery powers, and the other one considers fraud and debt. We are in the rather extensive stages of establishing our own review board for Wales that will look at solely devolved powers, and I'm really pleased that both Dave and David will be represented on that board, and WASPI in particular will, I think, form a big part of how we utilise the powers in Wales. And then I thought I'd just give you a few examples of how these have been used. There are hundreds of data sharing agreements. They're all publicly available. And if anybody wants to see a list, I'm quite happy to provide the link for them. But they've been used to identify fraud in the Help to Buy scheme. There's been an extensive data share between HMRC and local authorities, including some in Wales, to help households who are in council tax debt. And that's not just recovery, but that was around directing them to services that might assist them. And then the public service delivery powers, as I've mentioned before, the fraud and the debt powers are by far the most used. So identifying households who are potentially in fuel poverty, benefit eligibility checks for warmer homes schemes. And then there's a couple of very big examples, and they are extensive, but Dorset Council is also Somerset Council, who does something quite similar, has a whole family information sharing approach that is supported by a Digital Economy Act data sharing agreement that joins up a range of public authorities, and I think it's about 85 different public authorities, including Department for Work and Pensions, HMRC. It's got schools, policing, and a large number of their kind of third-party contractors to identify households who are vulnerable and to minimise the risks to them. Those are relatively new, but we're starting to see some really quite extensive uses of them. And then just a bit of a reminder about the benefits. We would like public authorities to use them. They provide a really clear, permissive gateway to using public sector data without you having to use or establish new legislative gateways. They were made available to deal with the issue of I don't know whether I can do this. This provides you with a very clear yes, you can. I will leave it there. I could go on for hours. I hope that was helpful. If anyone has any questions, would like to consider using them, obviously please pop them in the chat, but if you want a more extensive discussion, there's a couple of email addresses on there that I'm very happy to take queries on. That is it from me. I'm now going to hand over to David from the Information Commissioner's Office in Wales, who's going to talk about data sharing from the ICO's perspective, and I will stop sharing my screen.
Thank you, Anna. Thank you, Dave, Ben, Marcus. Prynawn da, pawb. Good afternoon, everyone. So I'm going to try and click on present now, and fingers crossed the joys of technology will do the rest. And hopefully you can see that rather cluttered opening slide there. So Dave and Anna, everybody so far has given a really good extensive explanation of some of the challenges that we all face, but also some of the practical solutions that are available. And I sit here with it from within the ICO. I think some of my colleagues are pretty envious of us, I think, in Wales, because we have got WASPI and we have got some quite advanced data sharing initiatives going on there. I think that would be fair to say. And I'm going to talk a little bit about what it's like from the regulatory side of it. So for those of you who don't know, I think Dave mentioned earlier, it's something about what happens when it all goes wrong. Yeah, that's usually where we come into play. And Dave also said that we haven't fined anybody or taken action against anybody for data sharing initiatives. That's true. sometimes we call it inappropriate disclosure, where sometimes information goes places where it shouldn't. But the closest we've actually had to a regular data sharing issue was with the Royal Free Hospital Trust in England. I had an arrangement with Google DeepMind some years ago now, probably about 5 or 6 years ago, and our investigation found that the information about 1.5 million patients with acute kidney injury was shared with Google DeepMind. This was not known to the patients, and our measure, we didn't take financial penalty in that position, but in that case. But there's no saying that won't happen now. But the good news is that, as the message today, data protection just simply isn't a barrier to effective data sharing, and we're here to help you empower your organizations to share that data effectively. So I've been with the ICO for almost 10 years now, and that's almost a decade of people coming up to me and saying GDPR says no, or data protection says no, which we don't hear quite as much as we used to, which is good. But thankfully, which is good because it's usually not true. And as Dave and Anna have mentioned, there's been quite a lot. There's quite a lot out there that say that. Now, one of the difficulties we have, we're talking about some of the myths around data protection today. When GDPR came in 2018, one of our key slides, one of our key issues was busting those myths, because there was a lot of misrepresentation about what GDPR would and wouldn't let you do, or mainly what wouldn't let you do, and the whole world was going to collapse because you couldn't tell your window cleaner where you were going to be on a Thursday or something like that. But I was trying to find a bit more of an up-to-date example, so I was doing some extensive desk-based academic research, and like most of us when we're doing that, I ended up on social media just browsing down a rabbit hole completely. But lo and behold, I did find something that was there, and it was quite a useful little post on X, formerly known as Twitter. And this was from an anonymous account, but I've cancelled the name of the account out just in case. Old habits die hard when it comes to redacting information, I'm afraid. So social media being this famously accurate barometer of nuanced public discourse, of course, this was a statement that was made on there. Now, there are many inaccuracies in that statement. There are some bits of truth in there, but there are lots of inaccuracies. And the good news is that you don't have to know what those inaccuracies are. The law is very, very complex. The information rights law is very, very complex. Almost every instant, every query is based around a huge range of contextual factors which determine whether or not things are likely or not likely compliant there. So you don't need to know that. But if you don't know that, then what probably doesn't help the public debate is replying with what you think is correct, because I think this did lend some rather amusing, or well, not amusing, I wouldn't say, but some other misguided takes. Hot takes, I believe they're called these days. So GDPR is not applicable in the UK. Technically, that's true. It's called UK GDPR, but it's basically the same. So I'm not sure if Brexit can be thanked there. It's only businesses that are recording it. That's a very, very common one. That's not strictly true. And GDPR, you can only assert rights over data that identifies you. Now, this is an interesting statement. Doorbells just record your image. You'll need additional data from another source to identify you. So what they're saying is that our image doesn't identify us. I probably disagree with that. I think it's one of the most things that identifies us more than anything is what we look like, after all. More about companies, and then this one is quite an interesting one because it goes on to mention consent, and I think consent does need some a particular bit of myth busting around consent there. In particular, it's often found out, certainly when GDPR came in, you have to give your consent to be able to do anything with data. So you go to the doctors, you have to give consent for all your information to be shared with doctors, etc. Strictly speaking, it's not true. Consent is just one of a number of lawful bases that can make the sharing lawful, and Dave and Anna have both mentioned a number of those, whether it's the legal gateway of the Digital Economy Act or other legislation. And the good news is that WASPI will make you think about these as well. So consent, just as a quick summary, consent, there are a number of aspects of consent which mean that it's not always that silver bullet. It must be fully informed. In other words, you must be told about what's happening with your data, and there must not be a power imbalance. So as the legislation says, specific and informed, and it must be freely given. And if you give your consent for something, you must be able to withdraw it as well. So that means that if you're sharing my data for some perfectly legitimate reason and you're relying on consent as your lawful basis, if I say I don't want you to share it anymore, you must obey that. in order for consent to be valid. So consent is very much not always the thing you should be relying on. You're all public servants. You've probably got it in your public tasks somewhere, or a legal gateway that enables you to do that. There. So that was just an interesting snapshot of some of the public opinion on that side of things there. Remember that if you do want the correct answer, then it will be it depends. So UK GDPR, to give it its full title, and the other legislation around it, it doesn't tell us that we can't share information. That's the really good news. It does tell us how we can share it and how we can share it effectively and appropriately. And as with a lot of things in the data protection world, it's a question of balance and getting that balance right. Now, your organization must be taking into account things to enable you to get that balance right. If you're way too heavily on the side of your organization and what you want to do with it, and it's at the expense of individual rights, then that balance is going to be skewed. And that's where you can run into problems. It doesn't say it can't be done. It just means that you have to think about these things and be able to identify risks and mitigate those risks there. So before you draw your line in the sand, you have to think about all these things here, your needs versus the rights of individuals. Now, there are a number of questions to help you do this, and I think we've briefly gone over those today. It is a huge, long process, so you can't talk about that. But as Dave mentioned, your purpose is absolutely key to everything here. If your purpose isn't correct, nothing else will follow into it. So with ethics, if you're wondering why, data ethics, fairness will often come into play here. Is it a fair thing to do to share people's data in this way? And again, if consent is an issue, like I mentioned earlier, there are going to likely be some ethical concerns. Just remember, just because we can doesn't mean we should necessarily. But there are other questions that are dependent on the why and your purpose. So the what information is going to be shared? Are you sharing the right amount of personal information to be able to achieve your goal? Are you sharing too much? Are you sharing too little? Either way will result in problems for you. You can use techniques like data minimization, anonymization, pseudonymization. These are all techniques that can be used to make sure that that information that is being shared doesn't present harm to the individuals in question. The how, you must share the information securely. If you're doing this via a technical solution, make sure the technical solution has been evaluated. If you're putting a database up for everybody to share, what's everyone's roles and responsibilities involved in that? And are there controls in place to make sure that people can only see what they're entitled to see? When, as I think Dave mentioned earlier, it must be timely, and you need to know if it's going to be regular or ad hoc. There's no point in sharing information after the need is gone. It has to be shared appropriately in a timely manner. And if you're doing it regular versus ad hoc, I would say with ad hoc sharing, I think there can be a greater fear factor around that, which is something that we're looking to address, and I'll get onto that in a little bit in certain sectors, because the ad hoc is when you have to give information out there and then. But again, WASPI can help you use techniques and put a framework in place to help your staff make those decisions effectively there. The who is really important because people must be at the heart of your process. At the sharing, it's the people whose data is being shared are absolutely crucial to all of this there. What do they know? Have you considered all their needs? But also, I'd like you to consider who is going to be processing the data as a result of the sharing. If your organization is going to share information, what are the other organizations going to do with it once they have it? You've got to ask yourself those things. And again, WASPI is just that really useful framework that enables you to tease out that information in the planning stages there. I've added where onto that because there can be some geographical issues with transferring data outside the EU, which I won't go into here because that's another 2-hour session in its own right as well. Anna mentioned data protection impact assessments earlier. They are absolutely invaluable. And in some cases, if they identify a high level risk that you cannot mitigate, you have a mandatory duty under the law to report it to us and to consult with us on that. So high level activity being lots of monitoring of lots of individuals, etc. I've just got my 5-minute warning, so I am going to rush through this now. So anyway, that's enough. Well, it's not quite enough from me, but I'm going to let you have a word from the Information Commissioner themselves. And if the joys of technology work, then you'll be able to hear John speak to you now. There you go. I don't think you can give that message any clearer than that. There, John committed to UK Parliament that we would publish guidance for safeguarding professionals later this year. That guidance is imminent, and whilst it revolves around the safeguarding profession, it will be really, really useful guidance, and everybody can read into what they want into that. My team will be sharing that with local authorities throughout Wales and various other public bodies, all our networks really, which is probably most of the organisations around here, I think, because we do know most of you. And we will be sharing that out once it's published, which will be very shortly. Do feel free to get in touch with that if you need to. Finally, here's a little bit more information that's of use to you now. This is a screen record, which I'm hoping has worked. I don't know if it's going to work or not, but we'll find out now. So this is the homepage on our website, and I'm going to hopefully show you where you can go on there. If you scroll to the UK GDPR and guidance, it takes you to this page here. If you click into that, scroll down a little bit and you'll see data sharing. And this is a page of resource purely about data sharing. And this is really useful. Dave mentioned our code of practice, which is laid before the Parliament. That's a code of practice we had to write by law. And again, that dovetails nicely with WASPI. It's something they complement each other really nicely. If you scroll down a little bit further here, you can see all the other resources. You will see something that says busting the myths around data sharing. And if you click on that, it will take you to this page, which will cover all the myths, including the one on consent I mentioned as well. So there's a really useful guidance, and there's more going to be coming down the line as well. So, you know, we'd love to hear from you on your thoughts about that. If you think there's anything we can do. The Commissioner came down last month and met with a number of key personnel within the Welsh public sector around data sharing, and it was a message he was very interested in hearing about that. So it's something that we're looking to work closely on in the future. And I think, oh no, it's going again. There we go. Final slide. Contact us. That's the ICO Wales number. You'll get through to us. That's our Welsh language helpline. You can speak to us in Welsh or English, and we will happily take any queries that you like and do our best with it. Sometimes we can facilitate an answer. If you get us involved early on in an initiative, we can give you that we can. The earlier we're involved in general, the more helpful we can be. We're not here to catch you out. We're not here to issue the fines. We're not doing that. We're here to help completely. So that's my message there, and I will hand back to Suzanne and stop sharing.
Thank you very much, all three of you. Thank you, Dave. Thank you, Anna. Thank you, David. That was fantastic, really informative. Very conscious of time. We've got a few questions in the chat bar, so if I can be so bold, if you could have maybe a look after the session and perhaps reply in the chat bar. I appreciate, obviously, for those who are watching the recording, you may not get the answers, but I wanted to just touch on the first one of these, if I can just take a little bit of time to do that. And it's a comment really that's just been about been raised, saying, you know, somebody wanted access to a map, and then you know, they were told we can't share that with you because of GDPR. I'm not going to go into the specifics of that, but I guess what might be useful is, what, if I can go to each of you in turn, starting with Dave Parsons, what would be your top piece of advice for somebody of how to kind of have those sensible questions if they do come across those kind of GDPR says no type responses? And that might be quite broad, so apologies for putting you on the spot, but is there kind of a real nugget of information that you would give people?
It's a difficult one, isn't it? I think we've all been there. I would imagine that all of us, even as professionals, have been in that situation where we've asked for something and we've been told you can't have it, and GDPR being quoted. I think, look, it's easy for individuals and for organisations to use data protection as that simple answer of I don't know what to do, and most of the time, 9 times out of 10, people will say it because they're afraid of doing something. So my general take on it would be to always go back and ask that question of why. You know, why can't I have something? Because I think asking that question why will by default then prompt the individual, prompt the organisation to go, yeah, well, I've just said no. Actually, what is the reason why I've said no? And, you know, let's not forget, as individuals, we're entitled to know why we're not allowed to have something as well. So there's a requirement on our organisation to advise us as to why we can't have it as well. So I think that would be the big thing I would take. I've been in that situation in the past from a personal perspective, and that's definitely been the first question I've gone back and asked.
Anna, anything to add to that?
I think Dave said almost everything I would say. I think sometimes it's helpful to think about why you need it to, you know, are you clearly articulating what the need is? And be careful if that need is it would make life more easy, it would make life easier for me to have this person's personal data. That's often going to be a reason why I've said no, I'm sorry. You know, if administrative efficiency isn't a reason for us to give you this. But if you can articulate a reason why it would benefit the data subjects in question, that's often a really helpful thing to do. And I think it's certainly helped me get over the kind of, oh, I'm not sure about that. If you can properly articulate that, that's also a really helpful thing. David.
I would add that each of almost all public sector organisations will have a data protection officer, and that's an internal source of expertise that you can use. I would encourage you to discuss the issue with those first of all, because you can get the answers that you might need as a result of that side of things. There, it's hugely in depth. Like I say, it's a very complex landscape of legislation around here. It's not just about sharing data; it's about processing. All processing activities are covered by the UK GDPR. Sharing is just one such processing activity. So I can guarantee you that some of the factors you wouldn't think of, it could be time and issue specific. But also the other advice I would say is, well, would I want this to happen to my data? I've noticed someone's put in the chat there about, you know, companies selling information they hold on us. And you know, would you want them to do that? If your organization is sharing data with somebody and you'd have questions about that, then the chances are the people the people that you're sharing data about will have those questions as well. So empathy is a strong skill to have.
Excellent. Thank you all ever so much. We are over time now, so all it remains for me to do is to thank our speakers again. It was absolutely brilliant. And as I say, the recording will be available online as well for anyone that wasn't able to make it. So thank you all three, and thank you to all our attendees. And hopefully we'll see you next time at our next webinar.
Diolch yn fawr.